Let's get more now on one of our top stories. A former public servant at the centre of a free speech case has lost her High Court fight today after it was found her tweets breached the Public Service Code of Conduct. I'm joined now by James Mattson, a lawyer with over 20 years employment and industrial law experience. Thanks so much for coming in. This is a really interesting case, isn't it? What were the arguments the High Court is likely to have weighed in this particular case?
Yeah, the main argument the High Court weighed in this case was whether or not the anonymous tweet, or the anonymous tweets, there were 9,000 of them, meant or provided some special protection for the public servant who had an obligation to at all times behave and uphold the APS values. And the High Court was not impressed at all by that argument.
And so ultimately it came down to the employment contract that Michaela Banerjee had signed?
Well, it actually came down to the legislation that governs the public service, and the legislation, Parliament actually saying public servants need to be apolitical, impartial, and that was the value that she was held not to uphold by her highly critical, intemperate tweets.
Does today's judgment shed any light on whether there's a difference between open and private posts, or posts under your name versus anonymous accounts? By this judgment, it sounds like they're all the same.
Well, the High Court said it's obvious, and the public servants were told this, it's obvious that you can tweet anonymously, but the risk is that you will be found out. And that's what happened in this case. People put the dots together and worked out that it was this particular public servant. The High Court wasn't impressed by the argument about anonymous tweets give you some protection. In one sense, if you are tweeting anonymously, it's probably because you know it's wrong, and there's perhaps a little bit of dishonesty there, and the High Court didn't like that.
Do you think this particular judgment today should serve as a warning to others in the public service, perhaps everyone who has signed an employment contract?
Yeah, I think it absolutely does. The High Court has said you don't have a free, unbridled right to do as you please. While you have the ability to have an opinion and to express it and say what you want to say on social media, you've also got a contract you signed or obligations under legislation that you have to adhere to. You can't put that to one side and say, because it's a political communication, I'm free to do as I want.
I suppose a lot of Australians do tend to assume that we have freedom of speech and freedom of political communication. Does this mean we don't?
Well, the High Court was clear. You don't have a personal right to free speech. What you can do is express an opinion, take part in a public debate, but you've got to weigh it up with your other obligations. And what the High Court was saying, the more senior you are, such as in the public service, perhaps the more circumspect or cautious you need to be.
Do you think this judgment is likely to spark a conversation about enshrining freedom of speech, perhaps in a Bill of Rights?
Look, I think that's been an ongoing discussion. It may spark a discussion, but there is also a balance in terms of what are your obligations under contract to your employer and under legislation, and where is that balance struck? What the High Court was clear about is at the moment where that balance will be decided is in tribunals like the Fair Work Commission.
James Mattson, thanks so much for coming in.
Thank you.